Good afternoon. This is the House Judiciary Committee. A little bit 2:25, not quite 2 o'clock. Sorry about that. We have a number of bills we're going to be voting on here shortly. And then we have the floor at 4 o'clock. So why don't we get on with it? Senate Bill 32. I don't see amendments on Senate Bill 32. This is the cross-file of whose bill? Anne Arundel. Delegate Chisholm's bill. All right, so Senate Bill 32. I think we voted on a version of this last year. Motion for a favorable. Is there a second?
Second.
Motion for favorable and a second. Are there any questions about Senate Bill 32? Delegate Erican.
Thank you, Mr. Chair. I'm just wondering, we have a cross-file of this bill that's identical, isn't it? A House cross-file?
I would imagine.
It's HB 229. Why are we not moving that when we moved it last year?
Well, we can take another look at that and add it to a future voting list if you'd like.
Yeah, I mean, I think it'd be
Or we can
nice.
hold
I mean,
them both.
I think it's Delegate Chisholm's bill, I'm pretty sure.
Or we can hold them both.
No, I don't care. I don't care about holding it, but I would love to have a conversation later about why we're not moving.
Okay, Senate Bill
Brian's
32 on the bill.
Yeah.
Questions on the bill? Delegate Erican.
Oh, I already asked my question.
Okay, that's fine. Are there any further questions on the bill? Seeing none, the Vice Chair?
Yes.
Yes. Valentine?
Yes.
Yes. Crutchfield?
Yes.
Yes. Carden?
Yes.
Yes. Tomlinson? Yes. Embry? Yes. Pasteur? Yes. Tolles? Oh, she was in the back. Schmidt?
Yes.
Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Stinnett? Yes. Congolo? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Sample Hughes? Yes. Moon? Yes. Conaway? It's not here yet. Kaufman? Yes. Williams? Yes. Okay, we're going to keep yes for tolls. All right. So that's Senate Bill 32. Senate Bill 125. Wait a minute. I've got all kinds of bills in front of me here. Senate Bill 125 is Senator Giles. There it is. Senator Giles' bill. This is the cross of which one? Oh, right, Julie Polakovich-Carr, and it's in the same posture as the House version. There's a motion and a second to move the bill favorably. Are there questions or comments on the bill? Seeing none, the Vice Chair?
Yes.
Yes. Valentine?
No.
No. Crutchfield?
Yes.
Yes. Carden? Yes. Tomlinson? No. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? No. Phillips? Yes. Stinnett? Yes. Congolo? No. Erican? No. Taylor? Yes. Simpson? Yes. Grammer? No. Sample Hughes? No. Moon? Yes. Kaufman? Yes. Williams? Yes. Motion for favorable is adopted on 125. All right, Senate Bill 181. There have been apparently lots and lots of conversations about Senate Bill 181 that the Vice Chair has been heading up. And I believe we've gotten to a place where we can have a conversation here and go from there. First of all, I believe there are amendments.
There are amendments.
All right, so my understanding is that the amendments to the Senate bill put it in a posture different than both the House bill as we initially passed it and the Senate bill. Is that correct?
That is correct.
Fine. So Madam Vice Chair, why don't you tell us what the bill does now and what the bill as amended would do?
parole. Okay, so the bill includes medical as well as geriatric parole. We meaning the House and this committee, already voted out the amendment to, regarding medical parole. So if anybody has any questions on that, let me know. So I'm just going to specifically speak to geriatric parole because that's where the substantive changes were. We changed the eligibility to 65 years of age, having served for 20 years, and having to be infraction-free for a group which is called 1A category of infractions, which tends to be the more major type infractions, for a period of 3 years. And we also, hold on one second, I'm trying to get to my section I need to get to here. So those were that's the criteria. And then from there, we said that the individual would be tested with what's called a risk assessment if the individual had been housed for or has been sentenced to incarceration for 40 years or more. And so we wanted to make sure that that group got a risk assessment. Everybody gets a parole hearing. It requires the department, DPSCS, on an ongoing basis to provide names and of individuals who qualify under this criteria I just spoke of, so that there can be an ongoing level of review for parole. And to pay for all of this, you will be happy to know that the bill prescribes that the payment goes out of the JRA.
All right. Questions to the Vice Chair about what the... Let's press the button. Motion for a favorable on the amendment would be, that's 293421. Yes, second. And a second. Any further comments on the amendment? Delegate Taylor?
Thank you. When we talked about this, so what's the difference in what we talked about before? I have in my notes that the risk assessment was only going to be for those that had a life sentence. Is that one of the changes in the Senate bill?
We did not state in the statute for life, that individuals serving a life sentence are required to have a risk assessment. That apparently is the policy of the Maryland Parole Commission now. So what is new for the Maryland Parole Commission would be those who are serving a term of years of 40 or more. So that's what we put in, and that's what we were able to agree to.
Thank you.
Further questions on the amendment? All right, motion for a favorable and a second on the bill as amended. Is there further discussion on the bill as amended? Seeing none. The Vice Chair?
Yes.
Yes. Valentine? No. No. Crutchfield?
Yes.
Yes. Cardin?
Yes.
Yes. Tomlinson? No. Embry? Yes. Yes. Pasteur? Yes. Tolles? Yes. Schmidt?
Yes.
Yes. Simmons? I'm sorry. Boucher? No. Phillips?
Yes.
Yes. Stinnett?
Yes.
Yes. Congolo? No. Arakan? No. Taylor? Yes. Simpson? Yes. Grammer? No. Sample Hughes? Yes. Moon? Yes. Kaufman?
Yes.
Yes. Williams?
Yes.
Yes, the motion is adopted for a favorable as amended. All right. Senate Bill 187. This is an administration bill regarding CDLs. We talked about this one before, once before. It also passed the House and the House Judiciary Committee in the same posture, I think, in the same posture, Holly, as the, okay, as we passed it. Are there questions? Could I have a motion on Senate Bill 187? There's a motion for favorable and a second. Is there further discussion on Senate Bill 187? Seeing none. The Vice Chair?
Yes.
Yes. Valentine?
Yes.
Yes. Crutchfield? Yes. Yes. Cardin?
To be consistent, I'll vote
No.
no.
Tomlinson? Tomlinson votes yes. Embry? Yes. Yes. Pasteur? Yes. Yes. Tolles? Yes. Schmidt?
Yes.
Yes. Simmons? Boucher?
Yes.
Yes. Phillips?
Yes.
Yes. Stinnett?
Yes.
Yes. Congolo? Yes. Erican? Yes. Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Sample Hughes? Yes. Moon? Yes. Conway is excused. Kaufman?
Yes.
Yes. Williams?
Yes.
Yes. All right. Favorable motion is adopted. 197, this is a cross-file of, and there's a motion for a favorable and a second already. And it was House Bill 123 that we already passed. This is in the same position. Any further discussion on this bill? Seeing none. The Vice Chair?
Yes.
Yes. Valentine?
Yes.
Yes. Crutchfield?
Yes.
Yes. Cardin?
Yes.
Yes. Tomlinson? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Boucher?
Yes.
Yes. Phillips?
Yes.
Yes. Stinnett? Yes. Congolo? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Sample Hughes? Yes. Moon? Yes. Conway? Kaufman?
Yes.
Yes. Williams?
Yes.
All right, that's Senate Bill 197. Senate Bill 348, it's a cross-file that I believe is in the same position as this was Delegate Crutchfield's bill, I think.
Move favorable.
Yes, there's a motion for a favorable and a second, so it's in the same posture as the way that this left the House. There's a motion for a favorable and a second. Is there further discussion on 348? Moving right along, the Vice Chair?
Yes.
Yes. Valentine?
Yes.
Yes. Crutchfield?
Yes.
Yes. Cardin?
Yes.
Yes. Tomlinson? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt?
Yes.
Yes. Boucher?
Yes.
Yes. Phillips? Yes. Stinnett? Yes. Congolo? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Sample Hughes? Yes. Moon? Yes. Kaufman?
Yes.
Yes. Williams?
Yes.
All right. Favorable motion is adopted. All right. The Senate Bill 356 is the cross-file of Delegate Fair's bill that would eliminate the criminal sanction for the transfer of HIV. There's a motion for a favorable and a second that I've heard. It is in the same posture as the bill that left the House. Are there any questions or any comments people want to make on this bill? All right, seeing none. The Vice Chair?
Yes.
Yes. Valentine?
No.
No. Crutchfield?
Yes.
Yes. Cardin?
Yes.
Yes. Tomlinson? No. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? No. Boucher? Yes. Phillips? Yes. Stinnett? Yes. Congolo? No. Erican? No. Taylor? Yes. Simpson? Yes. Grammer? No. Sample Hughes? Yes. Moon? Yes. Kaufman?
Yes.
Yes. Williams?
Yes.
Yes. The chair votes aye. 356. It's a favorable motion, and it is adopted. All right, 432. All right, we talked about this a little bit yesterday.
Oh, there's an amendment.
There are amendments, and I just need to finish writing things down. Okay, there are proposed amendments, I believe, but I don't see them off the top of my pile. So let me see. Do we have,
You got it the other day, as amended.
who, it came from Moon?
Yes, new
Delegate Moon, are you pushing your amendment? No.
Amendments I know of.
Grammar has an amendment?
421?
432.
432. I seem to remember that, but this is the second degree escape.
Oh, I see.
Somewhere in the depths of your email, it would be 113122.
Yeah, for those of you who want to see it, you could look in the email. It's on March 26th, and I can re-forward it if you need, but I'll explain it very briefly. What it does is it adds one charge to the list of charges that can be expunged. And this particular charge is failure to report. It's criminal 9405A2, and I'll read it. A person may not knowingly fail to obey a court order to report to a place of confinement. So this is the gentleman I've brought up for the last couple years from my district. He was a couple minutes late to an appointment at a court, and that was the only charge that stuck that could not be expunged from his record. And that's impacted him in several areas of his life, and he's asked that we make an attempt to deal with this particular charge. And I've actually changed this amendment a little bit, so it adds it to the list of charges which could be expunged, but I've pushed it back and I've included it for the list of charges that could be expunged after 15 years after the completion of sentence. So there were some concerns, I believe, from the prosecutors that they needed to retain this information for certain people. But this would say after a person has completed their sentence, everything is over, 15 years later, we would allow them to expunge this from their record after 15 years. So I'd be happy to take questions, and I'd move the amendment and ask for a second.
Motion and a second on the amendment. The vice chair?
I just want to ask a quick, thank you, Mr. Chair. I just want to ask a quick question, Delegate Grammer, when you get a chance. So in that situation, was the individual on probation?
No.
Oh, okay.
I think he had to come to court he essentially what happened, so everybody's wondering, he was with a couple friends, they got drunk, they got on a tractor, and the charges, yeah, it's ridiculous.
As one does.
The charges that he faced, even though he wasn't convicted of a theft, the charges that he faced were theft.
Theft, okay.
But the charge that actually sticks was, even though he wasn't convicted of theft, subsequently, he was late for a hearing, and he subsequently got charged for failure to report. So the trespassing, the potential theft, that's not an issue for him. What is an issue is he was late, and this particular charge is still on his record.
Is that a misdemeanor? Failure to report?
It's escape too.
Oh.
It's escape in the second degree.
It doesn't include escape, though.
I'm sorry?
It does not include escape in the way the amendment is drafted.
But that's what is included in escape in the second degree. It's part of the escape in the second degree part of the code. And it includes in A1, a person who has been lawfully arrested can't knowingly depart from custody without the authorization of the law enforcement or judicial officer. A2, which is what Delegate Grammer is getting at, is a person may not knowingly fail to obey a court order to report up to a place of confinement. And then in 3, you can't escape from a home detention order, a juvenile community detention order, a privately operated hardware secure facility for juveniles committed to DJS. So there are different kinds of assault in the second degree. And so what you're doing here would be just to address one part of escape in the second degree. And I kind of wonder, I guess in the case of your friend, he was charged specifically with that?
With failure to report, yep. And that's all the amendment includes.
I mean, the other part of this is that the other thing that they may have done is if they didn't, sometimes if you come to a detention center drunk, you failed to obey the court order. If you came to, you didn't do what you were supposed to do when you were reporting in, I would argue could be even debating about whether I've seen one where it's like possession of contraband, but I'll stop for a moment, let Delegate Cardin ask a question.
Scenario. So he was he was charged with theft, Delegate Grammer. He was charged with theft, but he wound up getting a conviction for failure to report. So did he not show up in court, or he showed up in court and everything was dismissed?
He was late to court.
He was late to court. So I'm not sure that this applies because that's a failure to appear in court, not a failure to report to detention, which is what I think It
was the court order.
Right. Because I know that there can be an arrest warrant issued for somebody who fails to appear, or they can have the charge of failure to appear. But that's different than failure to report to a court for a court order. So I'm just not sure that that's the right one. But
so he actually went for an expungement. He went for an expungement, and the prosecutors challenged him, and he actually has documentation which specifies this particular charge. Like he has all the paperwork. He's hired an attorney to try and get it expunged. So we've really drilled down. It is definitely that one charge. It's weird. Yeah, I can find it, yeah.
Delegate Taylor.
Is failure to appear an expungible offense?
I mean, I guess escape in the second degree, you have to be reporting to, where people see this, I don't know if the word is commonly, but where it does happen is people they don't show up to a weekend incarceration. They don't show up when they're supposed to report to the jail or to the prison. Or again, they fail to obey a court order that they're, supposed to go there and not be drunk, not be high, there are many other reasons that might be included in a court order though there. So when someone fails to appear in court, they can be subject to a bench warrant. The bench warrant is there to make sure that they come or that they are brought to the next hearing. Does that answer your question?
There's something called failure to report, there's something else, failure to appear, and maybe there's a failure to obey as well?
Well, so what Delegate Grammer is referring to is called escape in the second degree.
So, and that's the only place it appears in the statute, under
This specific thing, a person may not knowingly fail to obey a court order to report to a place of confinement. Yes.
Thank you. It's so crazy.
Delegate Simpson.
So it's about expungement. What would be the reason that this would need to stay on somebody's record? What's the value in it?
If they came back again.
Okay.
If they were, the question becomes, you're a risk to obey or not when you're behind the walls. And that's why we have not crossed that line when it's come to allowing escape charges to be expunged.
It just seems a little bit more of a, kind of a minor I don't know.
I think it's a little more than a minor administrative function.
So it's just information they want to know if this person needs to be watched better.
If they're convicted, not to be too over the top with it, if you're given if you were sentenced to some period of time, a lot of times it could be you're sentenced to weekends in jail. That happens, a fair amount. Part of the understanding is, yes, you have been convicted to this. We're not taking you in right now. We are going to, we're going to effectively count on you to show up when you're supposed to for your jail sentence, as opposed to going through door number 2 in the courthouse.
Okay, so how about if this charge could be expunged, if the original charge is an expungible charge, does that make sense?
So
So why would you want this to stay on their record if what they were charged with is expungible and they're able to expunge that? Why would you want this to be there?
I need to go back and look at the different statutes that are there, but it strikes me that there are not many that go sort of to the operation of the jail, that go to the operation and when you have to appear at the jail.
I mean, this comes across, it has the feeling of like the resist arrest. So sometimes you would say, well, this is very pertinent, but then there are other times in which it's subjective. And if that was the only charge as opposed to, does that make, am I making sense?
Say it again, please.
This just seems to have the same feeling of the resisting arrest. So sometimes that seems very pertinent, but then there are other times in which it seems very subjective and maybe like the only thing. And it just seems like, I guess I kind of get where you're going, but there's another part of me that's like, if you're able to expunge whatever it is that I'd done, why couldn't this be expunged as well?
I don't think we at all say that that you are able to expunge this part of the code based on the underlying crime that you committed that made that part of the code, that made you potentially fall afoul of the part of the code that you want to get expunged. We don't, it sort of falls back.
Still seems like a strange thing to have remain on your record.
I think that it's something that again, that we have, it is a line that generally speaking, we have not crossed as to, the administrative operation at the jails. And it's there in part because there is a tacit understanding that you're going into you're in many cases being given the benefit of the doubt to go and report at a specific time, and they want you to report at that time, and they don't want you to report high, and they don't want you to report drunk. And so in this case, if they then have a charge that they're seeking to get expunged down the road, it is there to help those law enforcement or the jail and or the prison be able to go back in time and look back and say this has happened before if it does indeed happen again.
And there is some gray area though too, because
we're in judiciary.
Maryland's
there's gray area and everything.
I know, but there's not like we're drivable. Like none of our institutions are like, on the bus route. And our bus routes aren't all that great, so it just seems like there are just an extra obstacle, perhaps. I'm just.
All right, Delegate Moon.
Okay, so I have a few things to say. One, I'm just looking plainly at 9405A2, and it's very plainly about failing to report to a place of confinement. So it's the section you're seeking to expunge is specifically someone who was sentenced to show up for incarceration and did not show up for their incarceration. And so I think Delegate Cardin is onto something here, that either there's a misunderstanding of the charge that was placed on your constituent, or they were mischarged or overcharged or something. I think that could well be what happened in this case. But that makes it very different than trying to help someone get a failure to appear, essentially, off their record, than trying to remove from the record that they didn't show up for their incarceration. And I think one problem immediately, I mean, it's different than an ordinary offense if the offense is you escaping the rule of law and the preconditions to the rule of law. And so at first blush, I would have a question about whether we're setting up problems with bail review and things like this. If you don't, someone who didn't show up for their incarceration is certainly a question mark for whether they should be released pre-trial, depending on the case, obviously. So I guess this is all to say, this doesn't seem like the kind of lightweight crime we might just lob on. Okay, we missed that one, carrying a solo cup or loitering. Sure, let's just tack this on at the last second, no big deal. It does seem to not be that kind of request. This is a little bit more substantial, and so I would resist throwing, I guess, this on at the last second like that. And it relates to, I also withdrew my own amendment, which I continue to agree with, my own amendment, but I'm withdrawing it out of, I mean, people seem to be concerned with the timing left about ping-ponging the governor's bill back and forth with the Senate to make these changes. So I just want to let you know I've withdrawn my own amendment out of the same concern. But honestly, yours is as substantive a question as my amendment was posing, and so for that reason, I would resist both my amendment and your amendment.
Delegate Grammer.
Thank you, Mr. Chair. So the ask for the refresher on the story is out, and maybe that, and I hope that comes back soon. Maybe if we could hold it for a couple of minutes, I can get that for you. But I do recall from the story of the gentleman, Mr. McNeil, I've brought several years. This wasn't actually a detention situation where he was being confined. I remember saying, well, that story is very ticky-tacky, and I don't see why you got prosecuted with that charge at that point. And I will say, just the way we've drafted this, I'm not super huge on adding a bunch of new charges to the expungement statute. But the way I've drafted this, in law, there are most charges you are required to, the earliest you can file them is 5 years after your requirements have been satisfied. Some years are sentenced 7 years after the requirements have been satisfied. This is actually 15 years. So we've given this person, with this amendment, 15 years on this particular charge. And I think it's really just in the spirit of what we're doing for expungements. We don't want these charges to just ruin a person permanently. And, I wish we would have asked more questions of Mr. McNeil. This was its own bill. This was House Bill 318. I wish we would kind of pick through that story when he was here. But I do remember hearing a lot of folks say they were very sympathetic with that. So for Mr. McNeil and people like him who have these types of charges, really just hanging up their life for no reason. This gentleman, he's had this charge. He's had no other charges since that time. He's really done well for himself and his family. And I just don't, if the purpose of expungements is to give people an opportunity to move on, I think for some charges, even those we find questionable, to allow someone after 15 years, they've reformed themselves and committed no other crimes, I think those folks should be, if we could bring people here to say, look, this is really hurting me, and tell their story, I have no other criminal record, I think we should think of those people in the general spirit of expungements, and that's why I'd asked you to support this amendment today.
All right. We've had discussion on the amendment. All in favor of the amendments, please raise your hands. 1, 2, 3. Okay, 3, 4, 5, 6. All those opposed to the amendment, please raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. The amendment is not adopted. We're on the bill. There's a motion for a favorable and a second. Is there any further discussion on the bill? Delegate Moon, for the record, I suspect.
For the record, there's language in this bill that requires the judiciary to consider the successfulness of the completion of parole or probation conditions and restitution. The amendment I would have offered would have changed that to a may and allowed the judiciary to look at these conditions rather than to require it for every single expungement application. I think that's cumbersome and will slow down possible automation. So next year, you may see me back on that. Thank you.
All right. Are there further, Delegate Phillips?
Thank you, Mr. Chair. And I wanted to go on the record. I was going to offer an amendment as well. But in the interest of time in moving this forward, I think this is extremely important bill to get for us to pass. And in thinking of my constituent, Mr. Coleman, we're going to move forward. But I do want to go on the record because I looked this up. They did a study in New York, 2012 to 2014. They found that black defendants were significantly more likely than white defendants to be additionally charged with resisting arrest. Another study in California from 22 to 24, 19% of all stops resulting in the sole charge of resisting arrest were African Americans. Ferguson, after Ferguson, 2015, 2012 to 2014, every individual arrested for resisting arrest was black. We took that out. I believe we got to come back at some point and address that issue. Thank you, Mr. Chair.
Thank you. All right, are there further comments or questions? Seeing none. The Vice Chair on the favorable motion.
Yes.
Yes. Valentine? No. No. Crutchfield? Yes. Cardin? Yes. Yes. Tomlinson? No. Embry? Yes. Yes. Pasteur? Yes. Tolles? Yes. Yes. Schmidt? No. Simmons? Boucher? No. Phillips? Yes. Yes. Stinnett? Yes. Yes. Congolo? No. Arakan? No. Taylor? Yes, in agreement. Simpson?
Yes, and Phillips.
Grammer? No. Sample Hughes? Yes. Moon? Yes. Conaway? Yes. Kaufman? Yes. Williams? Yes. Motion's adopted. And we will now move on to our next bill, Senate Bill 443. There's a motion for a favorable and a second. This is part of a House bill that we passed across the street, correct, Delegate Moon? Which part of this is this? This is the felony firearms trafficking. So what does it do?
Upgrades from a misdemeanor to a felony, bringing in guns from out of state.
Okay.
Move favorable.
There's a motion for favorable in a second. So is there discussion on the bill? Seeing none. The Vice Chair?
Yes.
Yes. Valentine?
Yes.
Yes. Crutchfield? Yes. Cardin? Yes. Tomlinson? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Boucher? Yes. Phillips? Yes. Stinnett? Yes. Congolo? Yes. Arakan? Yes. Simpson? Taylor, sorry. Taylor votes yes. Sorry. Simpson? Yes. Oh, God. Grammer? Yes. Sample Hughes? Yes. Moon? Yes. Conaway? Yes. Kaufman? Yes. Williams? All right, so that goes across the way. And now Senate Bill 533. And we last left our story. There's an amendment. All right, good Lord. All right, the vice chair has been working on this pretty extensively, so we're going to listen to the vice chair now. There's a motion on the amendment and a second on the amendment. We're discussing the amendment now. Why don't we do that, Madam Vice Chair?
Okay, thank you, Mr. Chair.
Great.
Senator Cardin, Delegate Cardin, and Senator Folden have agreed to these amendments, just to let you know. So what we are doing is essentially making sure that we speak to the time and the statute of limitations in which an incident is under the process of review by the investigating unit through the time that it's presented to the Administrative Charging Committee. They still have a year and a day, and it's still based on filing the complaint by the citizen, but we just changed it to the presentment because above that, we state that the Administrative Charging Committee has 30 days, and we want to make sure we give them their 30 days. Because we were finding that they weren't getting the time that they needed, or that is prescribed by law, I should say. And so we made that change. We also stated that for internal complaints, internal within the law enforcement agency, that they're required to be reviewed within a year and a day. And lastly, we stated that for criminal investigations, and Administrative Charging Committee or the law enforcement agency must file the administrative charges within a year and a day after there's been an investigation, there's been disposition of all the criminal charges, or the Administrative Charging Committee or the law enforcement has received timely a notice that the appropriate prosecutorial authority declined to file criminal charges. And so that is the bill, and that's what it does.
Questions for the vice chair?
Oh, that's the amendment, I should say.
And so, thank you so much for that detail. And so, just to confirm, this is different than what we did here. And so, is that what you're saying? And so, the second amendment that was added on in the Senate, I'm trying to figure out if that's something that the police wanted or in agreement with, or if it's something that I know they've been working on this bill for a couple of years, so I want to see if folks have been at the table in some agreement.
Yep, they've been at the table, everybody's been at the table. We had a conference call with 20 people. So if you look on page, I think it's page 2 of the bill. Yeah, page 2, under section E and F. That is specifically what law enforcement wanted with respect to being able to handle their internal complaints, as well as being able to, what to do with respect to a criminal investigation.
And this is the bill, that this was added on, because it's my understanding they wanted G, but this was added, so you're saying law enforcement has agreed to this particular
Language, yes.
language that was added in the Senate?
Yes. Well, the Senate didn't add this. It came over
Let me back
to
up.
us
I'm sorry, we did
differently.
do something on the floor where this was asked to be included. Is this what was asked to be included?
No, what was asked to be included was actually at section D on the floor.
Okay.
And that was an amendment, and we took care of that by the language of stating presentment to the Administrative Charging Committee, because we didn't want to the Police Accountability Act does not give a timeline in which a citizen may file a complaint. So we didn't want to do anything to change that. So we have the language that it is filing of a complaint by a citizen. What was suggested was when it is, when the appropriate official knows or becomes aware of the incident, we did not accept that language because it's too,
Subjective?
no, it's too, it changes the rights of that we gave to the citizen to file their complaint, which is an unlimited timeline.
Okay, so, yeah, okay, so that's the part, the D, it wasn't E. They okay with E, but D.
It's the old,
Right.
it's the old C that is now D.
Okay. And so usually what happens, you have to, my apologies, I have some bills I'm working on and trying to get through the finish line and then trying to remember everything we did here. So I appreciate your patience. I'm trying to figure out what was, I hear what you're saying, you didn't want to lose the ability for the citizens to be involved, but what was the discussion, I wasn't in the room, in terms of when it would be filed, or when they first knew about it? Because oftentimes it hangs in the, out there in the universe for a year, 2 years, 3 years. And so I was trying to figure out those that were part of that conversation, was there further explanation in terms of that particular piece of having it?
Right. So we did talk about this section. This was not as much of a concern, much of a priority for law enforcement as E and F. And D was a huge priority to, what we tried to do was give to law enforcement their priority, and as well as maintain the integrity of the Police Accountability Act. So we were able to do that through E and F, because their priorities were the internal and the criminal. So that's where we focused, that's where law enforcement got a chance to fully get what they wanted, ask for what they wanted.
Okay.
With respect to the date when the law enforcement agency became aware of the incident, that was a bridge too far. Quite frankly, it's a bridge too far because of what is currently in the Police Accountability Act, which states the filing of the complaint by the citizen. If we stated that it's the date that the official became aware, then we're limiting the time in which the citizen can file their complaint. So that is the impetus behind D.
Okay, thank you.
All right. Any other questions on the amendment? Seeing none. All in favor of the amendment, please raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15. All opposed? 1, 2, 3, 4, 5, 6, 7. The amendment is adopted 15-7. We're on the bill as amended. Motion for a favorable and a second. Delegate Cardin now, please.
That after 3 years of doing this, and Delegate Bartlett did a masterful job of bringing everybody together, and we didn't all agree on everything, but she really did a good job of trying to get everybody at least something that they needed for it, and I'm hopeful. And I'm happy that the FOP seemed to be okay, the chiefs and sheriffs seemed to be okay, I think that the OPD got some of what they needed. I think everybody kind of came out okay, so I'm very happy about this.
Further questions on the bill as amended? Seeing none, the vice chair?
Yes.
Yes. Valentine?
Yes.
Yes. Crutchfield?
Yes.
Yes. Cardin?
Yes.
Yes. Tomlinson? Yes. Embry?
Yes.
Yes. Pasteur? Yes. Tolles?
Yes.
Thank you.
Yes. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Danette? Yes. Congolo? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes, and a kudos. Grammer? Yes. Sample Hughes? Yes. Moon? Yes. Conaway? Yes. Kaufman?
Yes, and a kudos to the vice chair.
Yes, indeed. And Williams?
Yes.
Yes, and I add to my great appreciation for the vice chair for working so hard on this challenging issue. He spent an enormous amount of time on police reform in 2021, and we'll continue to deal with these issues, but it's also an indication of the challenges that come with these bills, because we're trying to make sure we keep the overall system together at the same time. All right, Senate Bill 566 is Senator Sidner's bill. That's the filing fee. It raises it to, it raises it to $450, I think, from $300.
Move favorable.
$450 from $300. It's in the same position as the bill we passed. There's a motion for a favorable. Is there a second? There is. So here we are on the bill with a favorable. Are there any questions? Seeing none. The vice chair?
Yes.
Yes. Valentine? No. Crutchfield?
Yes.
Yes. Cardin?
Yes.
Yes. Tomlinson? No. Embry?
Yes.
Yes. Pasteur? Yes. Tolles? Yes. Schmidt? No. Simmons? Yes. Boucher? No. Phillips? Yes. Stinnett? Yes. Congolo? No. Erican? No. Taylor? Yes. Simpson? Yes. Grammer? No. Sample Hughes? No. Moon? Yes. Conaway? Yes. Kaufman?
Yes.
Yes. Williams?
Yes.
Motion is adopted on Senate Bill 566. And so we move on to U visas. Delegate Embry has been part of this. There is an amendment. And I believe that there's conforming amendments on the House bill that's being put on. Am I right about that? Delegate Embry, why don't you tell us what the amendment, well, there's an amendment. Oh, can I have a motion on the amendment? Motion for amendment and a second. Great. Let's talk about the amendment. I see you, Delegate Erican, Delegate Embry.
We are conforming it almost entirely to the U visa bill, the U visa section of the bill that we passed, with the one exception that we're keeping the time frame that is in the Senate bill, which is a little longer. It gives the certifying official 45 days instead of 30, but it is otherwise identical, again, to the U visa section of the bill we've voted on.
All right, so this is only about U visas. The U visa bill that we passed had other things attached to it. This does not have other things attached to it. Delegate Erican, then Grammer.
Okay, thank you so much. So can you kind of walk us through what the process will now look like under the new amendment? How once like a crime is committed and somebody calls it in, what's going to happen to that person now? How's that going to shift and change?
Delegate Embry.
Change much. It's sort of, this is all federal law, so we're just trying to put a little bit more federal law into state law, which we'd already done years ago, so that we have consistency around the state. So if you are a victim of a crime, you can at any point, and that's under federal law, we do clarify that, at any point petition a certifying official. Usually it's police or prosecutors, it can be other, it can be the court. You can say, I have a victim, would you certify this, I think it's Part B for the U visa status, and they have to certify two things. One, that they were in fact the victim of a qualifying crime, and B, that they were helpful. And so this is just giving more, reinforcing our state law with the existing federal law and guidance and regs.
Okay, and it wouldn't exclude people who are also witnesses to crimes as well, right? So I know, at least in the case that I was familiar with, there was several people murdered, they were victims of the crime, but also there was witnesses
Yes.
to the
Yes.
crime?
Yes.
So it includes those
Yes.
folks as
And I
well?
apologize for
Okay.
not saying that. Yes.
Okay, awesome. Okay, yeah, I mean, I think as long as we're keeping the two separate bills separate, I would be supportive of this today. It will, I think, will lower crime in immigrant communities.
Delegate Kramer.
My questions were answered, thank you.
All right. Are there any other questions on the amendment? Seeing none, all in favor of the amendment, please raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 20. Great. Anybody opposed? Amendment's adopted unanimously. All right, we're on the bill as amended. There's a motion for favorable and a second. Any further discussion on Senate Bill 608? Seeing none. The Vice Chair?
Yes.
Yes. Valentine?
Yes.
Yes. Crutchfield? Yes. Cardin? Yep. Tomlinson? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Stinnett? Yes. Congolo? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Sample Hughes? Yes. Moon? Yes. Conaway? Yes. Kaufman? Yes. Williams? All right. Senate Bill 608, favorable motion has been adopted. We have to hold off, not because he walked out of the room, but because there is a technical mistake that we've discovered in 655 and 966. We're going to come back to them. Have no fear. But now it's time for Buddy's Law, everyone's favorite. Really? Okay. That's fine.
Move favorable.
This is, there are no amendments to this one. There's a motion for a favorable and a second to Buddy's Law. All right, and is there further discussion about Buddy's Law? Delegate Williams.
Whenever we've had these types of bills in our committee, typically during the bill hearing, we have had some real-life examples of
The death of a pet? Bills about the death of a pet?
Well, no.
We're not doing that in here. No, I'm sorry. You're saying, I believe.
Yes, we have had the actual pets here who we don't want to die.
That's okay. It's a little late in session, but I mean, come on. I would be happy to reach out to the courthouse. There's a great program in Anne Arundel County where they have service dogs at the courthouse, and perhaps if they're available, and if everybody's good over the next couple days, we can see if one of them might make a visit.
Yes, we'll be good.
Okay. All right. It's kind of getting weird. All right.
Oh, yes.
Okay. Do not make me pull this committee over, all right? I can't. I just can't right now. All right, so Senate Bill 581, there's fortunately, no further discussion on this bill. And we'll go to the Vice Chair.
For Buddy, yes.
Yes. Valentine? Yes. Crutchfield? Yes. Tomlinson? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Stinnett? Yes. I think the point about Buddy is never mind. Congolo? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Sample Hughes? Yes. Moon? Yes. Conaway? Yes. Kaufman? Yes. Williams? Yes. Motion is adopted. In one of our last bills, we're going to talk about We're going to talk about the Child Victims Act here in a moment, and that's House Bill 1378, so don't rush for the door after this one. We're going to talk about it for a few minutes. Senate Bill 811 is the task force on the creation of a division of returning citizens. Delegate Taylor has been working very hard on this, and there appears to be some questions about a date. And so the committee, the chair would seek to conform the Senate bill to the way that this bill left the House and fire it back over the fence. Is that okay with you, Delegate Taylor? And Senator James is expecting that? All right. Then we will do that if everybody agrees. There's a motion to accept the amendments. Is there a second? Yes. All right, so this would be an amendment to conform to the House bill, which was House Bill 646. Any questions on the amendment? Great. Oh, see, I'm already doing something nice for you, and now what? Delegate Taylor, sure, go ahead. Sorry. I don't have that one. I only have the one that changes the date. You wanna, we can fix it.
It's James.
No, is it okay to go forward with just the date amendments, or?
Yeah, that was amendment number 2. Amendment number 1 added name.
What names did you want added?
I'm sorry, there weren't my names, it was senators.
So you're looking, you would be adding senator sponsors onto the bill? Yeah, we can't do that anyway.
No, it came to us.
Just go, just, we're
I'm
good.
fine.
It came out.
So yeah, no, we don't, yeah. You don't have to
That's
worry
not
about
an
that
issue.
part. The question, we are
Just tell 'em
conforming
start the
this
car.
part to the House bill.
Yes.
The substantive part, and yes.
They can do what they want.
Great.
Dad, everybody's on board.
All right, now, any questions? All in favor of the amendment, raise your hands. Anybody opposed? Doesn't look like it. Any further discussion on the now conformed Senate Bill 811? Seeing none. The Vice Chair?
Yes.
Yes. Valentine?
Yes.
Yes. Tomlinson? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Stinnett? Yes. Congolo? Okay. Erican? I'm sorry? No. Taylor? Yes. Simpson? Yes. Grammer? Yes. Sample Hughes? Yes. Moon? Yes. Conaway? Yes. Kaufman? Yes. Williams? All right, that's Senate Bill 811. All right, I'd ask members of the committee for the next about 15 minutes, and then we will adjourn at that point, 3:45, to look at House Bill 1378. There is an interlineated version of the bill with amendment number 853229 at the top. What the bill as amended would do, the bill as it came in would simply put a end date on claims that under the Child Victims Act that we passed a couple years ago. What the bill as amended would do is it would do several things. One, prospectively, from the date of the effective date of the bill, which it would become June 1st, 2025, it would lower the amount of the cap for both private and public defendants. It would lower the cap for private from 1.5 million to 700,000. It would lower the public from 890,000 to 400,000. It would say that going forward, for claims brought after October 1st, going forward, that it would be a claim or claims, in other words, all of the different occurrences would be happening under one umbrella. The bill then also says clearly that the attorney's fees in these kinds of cases would be 20%, would be capped at 20% if a settlement was made, or 25% if a judgment was made. In other words, they went to trial. We ask the Supreme Court of Maryland to adopt rules to implement provisions of the Child Victims Act. In other words, it's basically signaling to them, hey, you're going to have a number of cases. You should probably look to get together and draft rules. And then we also, in uncodified language, say that every year the judiciary shall report the amount of each award that was made to a claimant under the Act and a summary of the claims underlying the award made to each claimant. Again, the effective date would be June 1st, 2025. So with that, I'm not going to go to debate on whether, I'm going to try and tread a line. If you've got questions as to what the amendment says, we'll focus on that now because we don't have a whole lot of time. And then we'll go from there. Delegate Erickson, then Kaufman.
Thank you, Mr. Chair. Okay, so it is a lot of stuff in here, and I couldn't read it as quickly as I wanted to. So basically what we're doing is we're making a separate policy for those who have already filed up until a certain point. They are going to be under our previous law that we made. And then going forward, we're separating the two groups out still, or is everybody having the same cap?
No. So there still would be two different caps. Private caps would be 700,000. The idea was that they were proportionately, the public cap would be 400,000, which is the same as the local tort claims. So we were going for a round number that was roughly the same percentage for the private side, which lowers it from 1.5 million to 700,000.
Okay. So we are lowering the private, but just from
Yes.
1.5 to 700, and then.
We're also making clear that the attorney's fees, no matter who you're suing, would be 25 and 20%, depending on whether you went to trial or not.
So 25, I assume, if you go to trial.
25 if you're going to trial, 20 if you're not.
Okay, thank you for explaining.
Delegate Kaufman.
Yes, I just wanted to ask, is Chair Wilson comfortable with the amendments?
Yes.
Thank you.
Just to be clear, there are certainly competing interests here, and I've heard a lot from a lot of different people over the last week. But I think it's at a place, I think, that is fairly close to being a place where I don't know that everybody's totally happy or totally unhappy, which has been stated our goal from time to time. Delegate Grammer.
Thank you, Mr. Chair. So I wanted to kind of ask to the value statement as to why we're even entertaining this. We have a bill for reparations this week, which you can assign what value you like to it. But for these folks who we've heard over years and years and years have quite literally gone through hell, we're putting a different level of justice for people who have been abused in a private setting and people who have been abused in a public setting. And while all of them are horrific, it's arguable that most of the people who were abused in some kind of public setting were also detained and had no way out of this situation. So can we speak to, I know there's a lot of different interests involved here, but I just want to see if we could take a moment to speak as to why, like, we've heard a lot about over the last year or two about limits on damages at all. And the more I hear about it, the more I'm inclined to say we shouldn't have any caps on damages, because, how do you even quantify what these people have gone through? And many of them have had their entire lives wrecked. So can we talk a little bit about why we're lowering the caps and why we're creating two different levels of culpability here?
I think that one of the things that's the hardest part of talking about is we want to make sure that these people are getting their opportunity to be heard, certainly in the judicial system, that we learn more, and we learn, quite frankly, I think a little faster, what some of the terrible things that did happen, both in the public and in the private realm. One of the ways to do that is by encouraging people to file those claims, to get those claims in, and to begin to adjudicate those claims or come to a settlement with those claims. One of the things that came up during the hearing very clearly was the question is, how do you address all of these, the costs to the state? And how do you do that in light of the fact that some of the facts that are starting to come out are awful? There's no question that there have been people who were victimized, and that's why there is this structure. I think, and I know from years and years, and you were sitting on the committee as well during all the way through this, over and over again, we heard this isn't about the money, this isn't about the money, this isn't about the money. It's about getting justice, and it's about having their voices heard, and having that pain recognized. And again, I don't think there's any amount of money that's going to completely recompense people for what they've gone through and what they've had to experience. But we need to be able to bring these cases out into the light of day. And so I think that by doing this, it will help to be able to begin to get an idea without completely closing the door. And I'll get to that in a second. But it gives us an idea of the universe that we're looking at, so that we can look at what services these people are going to need and look at the cost to the state that's going to exist. Add to that, I'll just stop there. But I think those are some of the challenges that we face, that we're facing here. And it is not easy. It is not a position that we want to necessarily be in. But I think we need to start moving in this direction. Delegate Grammer, did you want to come back? Go ahead, Delegate Grammer.
Thank you, Evan. So when we talked about this bill, there were a handful of people that wanted to vote against it. And what they said in this committee and on the floor is they said, this isn't about the Catholic Church. This is going to affect local governments. This is going to affect institutions. This is going to affect a lot of people we're not thinking about. And they were exactly right. And the way it seems, and I just want to say this to the record, is nobody accounted for the fact that the state there have been so many cases of abuse in the state. It may even be more, we may have been talking and thinking about the Catholic Church, but, it surprised everybody the amount of cases that had happened to people in state custody. And it seems that right now, we're not really, if we should be thinking about the cost of helping these people get through their lives, that's, $400,000 is nothing. And it seems what we're doing right now is we're saying, how can we protect the state and its budget? And with the cost of living in general, it's not about the money, but it's about making a person whole. And I'm not sure we're doing that. I'm not sure how a different level of justice for public versus private makes these people whole. And in this moment, it very much seems like we're not thinking of these folks. We're actually saying, what are we going to do about the budget? So I just don't feel comfortable with this at all. I wish we had some kind of product. If we have a problem we need to fix, that closed the loop and kept the victims in mind.
I think that one of the things that's when this bill was first introduced, it set a hard stop. And I think some of the conversations that I was part of, and others in the committee may have been part of, felt that would have been even worse, without question, for victims. I guess it's difficult in this situation to kind of go through varying levels of how bad this could be and say, well, this is not as bad as it could possibly be. I mean, I will 100% say it's not my strongest argument. But I think what we're trying to do here is we're trying to acknowledge that there will be people who still continue to come forward, whose claims were barred. I want to say, there's a distinction. The universe of people that we're talking about here are, a universe of people whose claims were barred in the past from coming forward. So we want to keep those doors open for those people, so that those stories can be told and so that they can be heard. While at the same time, for what it's worth, under the current law, we had changed the existing statute of limitations so that going forward, we hopefully would not have ever a similar problem to what happened to the people whose claims were barred. So, look, is it a perfect solution? No, there's not a perfect solution here. It's part of the reason that we came to the place we came to the bill 2 years ago. But this is where we are, and we're trying to get a better sense to define that universe so that we can go forward, so that those conversations can happen and get people closer to the help that they need. Vice Chair.
Chair, and I have to say that unfortunately, there is no making whole. And the testimony I heard on this bill, when it came to the dollars, was less from the victims. I heard one individual say, I just want to be able to get therapy. And I think that acknowledging the wrongdoing is not, as they say sometimes, is not for nothing. Acknowledging the wrongdoing is huge. And I'm not saying that money is not important, because it is, but I just wanted to point out that a lot of people did say it wasn't about the money, it was more about the acknowledgement about being able to explain their story, tell their story, and be an advocate in some ways to help other people. So I know, Mr. Chair, you said you didn't want to get into debate, but I just wanted to make that one little comment. Thank you.
No, I appreciate that. Delegate Eric.
Thank you, Mr. Chair. I appreciate the discussion of this bill further. And I did hear a lot of the testimony that it wasn't about the money, but if we think about the life experiences of a lot of these folks, it's going to be hard for us to divorce what their lives are like after such an experience from pretty severe financial loss. So whether that's in their forefront or not, we as a body should be able to say, that may not be the first thing you're concerned about, but your life has been changed in a way where potentially you've lost access to what you may have otherwise been able to create, this wealth that you may have been able to create and then pass down to your offspring. So that loss, I think we should consider whether or not they are considering it or not. And I just really quick did some math, and if a child was, let's say it was a boy molested at 14 or 15 while in the care of DJS, let's say he lives to life expectancy for a male in America, we're looking at like $6,000 a year if he gets the maximum. That is nothing. That is less than nothing for a child whose life was really taken from them, because you might get through an experience like that, but you might not actually survive it, even if you're there still. So I think $6,000 a year is offensively low, considering that these children could not escape their abusers.
All right. So where we are is as follows. We will be voting tomorrow morning at 9 o'clock. If you have amendments to House Bill 1378, this is your fair warning. The committee would like to accept them as soon as you get them, and understanding that it's a little late in the day, but the amendment office is still open. So, and is still very much still open. So if you have amendments, please give them to the committee. If you want to speak to me, there's been a lot of conversation that's gone into this so far. Happy to speak more and kind of give more insight. I'm happy to talk to people. So feel free to find me on the floor, text me, what have you. But for now, we will stop with this legislation, and But again, expect votes tomorrow morning at 9. Also expect votes after the first session on Wednesday as well. I'm going to, well, with that, I'm going to adjourn us. I'll ask people to hang on for 5 seconds, but this has been a hearing of the House Judiciary Committee. I'm going to assign bills, and then we can head to the floor. Thank you very much.